My lord, may I pray for leave to file this contempt application and move this application on urgent basis. On second, your lordship set aside the impugn order which has been passed by the subdivisional controller cancelling my license. Your lordship set aside the order and directed to immediately reinstate in accordance with law. My lord, I have communicated that order. That order has not been complied with. If for the April, the beneficiary are not getting the goods. My lord, this is the order. My lord, I pray before your lordship kindly give me leave to move this matter on at 2 or my lord, today is 29th. My lord, at least one day I can distribute the goods.
You can move next week.
My lord, as your lordship.
My lord, I am
Next
mentioning
week.
for inclusion or restoration.
Today is not the day of mentioning.
My lord,
Okay.
it's a restoration application.
Come on Wednesday, next week, Monday. Call the list.
Well, Lord, if your lordship recollects, this is the matter where your lordship has
This is
substantiated.
second matter.
Yes, it is. It is.
Lord, before
Right.
my learned friend
Mr.
makes
Chaturvedi was arguing in this matter.
Lord, before my learned friend makes any submissions, Lord, I apologize to my Lord for the delay. But my Lord, I on my behalf and on behalf of my Lord, all the members of the bar, my Lord, congratulate my Lord.
Thank you.
My Lord,
Yes, yes.
and we wish my Lord a very meaningful and fulfilling Lord tenure in the August office as a judge of this court, my Lord.
I need your cooperation.
That my Lord would always be there. We are
Yes,
so
I know
grateful,
it is already there. So, in this matter,
my Lord.
you
Yes.
are arguing.
Let the
They have
cooperation start
completed the
from this
argument.
matter.
Due to the change of determination, I have left the matter.
My Lord.
So now I can understand all notings are there. I can read it.
My
So
Lord.
when you can start, it is up to you. Not this week. Not this week.
My Lord.
Come on next week, any day.
My Lord,
So that I
next,
can arrange my diary like that.
my Lord, next week, my Lord, I have my Lord, some personal difficulty.
Very good.
But the week thereafter, my Lord, kindly my Lord, sees if it permits my Lord's my Lord, convenience and the convenience of Mr. Bose.
I am always available, my lord.
Now
Your
you have to
lordship's
start. You
convenience
are
is more
arguing
important.
this
Yes, yes, my Lord.
So that's why I'm asking you. So week start from 13th May.
My Lord.
You
My lord,
say.
I was respectfully submitting if it could be, because your lordship usually takes up these matters on Thursday. So if it could be on the 8th of May, if my
Next
lord,
week,
Difficulty is
Whole of
that
next- whole of next
8th of May, 8th of May, I have only other determinations. Group 1 matters are
Oh,
there.
I see.
Thursday, Friday, I take up the group 1 matters.
13th May, can we come?
Specially assigned matter
My.
on Monday, Tuesday and Wednesday.
So 13th May, we should come. Can we come back on 13th? Monday ছুটি আছে 12th May?
Monday is the holiday.
Yes, 12th May.
13th এ কটা matter আছে দেখুন তো 2 p.m. কিসে 2 p.m. 12:30 কিছু ফিক্স আছে 12:30
12th ছুটি আছে।
না না 12:30 12:30 কিছু আছে তারপর 12:30 কিছু আছে
বলি।
So you can come on 14th May 12:30.
14th May, 12:30.
12:30.
I'm grateful to my Lord.
Okay. Please take down. This is a
Devan.
specially assigned matter previously heard in part by this court. Let the matter fixed on 14th of May 2025 at 12:30 p.m. for hearing of this matter.
My lord, in order to cooperate with your lordship, my lord, if my learned friend gives us in advance the judgments that he wished to rely upon, then we can keep quickly, when we rejoin, we can quickly deal with
Let
them.
him finish first.
That's what I'm saying. No, I
Thereafter-
said if he gives us the citations only, not the judgment, just the citation that these are the judgments he wishes to rely upon, if any, then we can immediately.
As and when the course of argument, my Lord, proceeds, my Lord, I shall cite and I shall hand over copies. My
Yes.
learned friend, my Lord, need not
No issue.
bother. Without my Lord's intervention, I shall do it.
You have the right to reply. I am giving.
That's what I'm saying. We would have replied that day itself and finished it off.
Take this moment now.
Okay.
I'm so very grateful.
Okay, thank you.
Deeply okay.
Next.
Unit 12 are identical matters. Lordship, the petitioners were supposed to give reply. We had submitted a.
We are for the petitioners, my lord. I'm led by my lord, Mr. Sagar Bandopadhyay, senior advocate also, my lord.
What is the matter?
My lord, the confiscation or not? Yes.
But I have also been briefed in this matter for petitioner.
No, it is a confiscation. My lord, there's a confiscation process was going on because of the SDOs and remand back it before the SDO and that was challenged by my lord.
Filing the reply so far the opposition filed by the first matter.
Yes.
No, item number 2 এ লেখা।
না প্রথম matter.
Item number 1.
না 2 1 তো হয়ে গেছে।
তো হবে না।
You are on which matter? Item number 7. Reply. Opposition. You are appearing for the state in this matter. Okay.
Total কত matter আছে? There are 10 matters, my lord. বলছি কথা এখন নেই, রাতে ফিরেছে দিল্লি থেকে একটা সময়।
হ্যাঁ 100 এইটাই দেওয়া হয়েছে আমার।
All points are involved in the matters are all same. So your lordship may dispose the first matter. It will cover everything.
আমাদের কপি পাইনি তো।
কোনটা গো?
রিপ্লাই কপি।
এটা copy?
না বাকি
না।
দুইটা থাকবে বাকিগুলো তাহলে একটা যদি
হবে না,
অর্ডার পাস
দেবে,
হয়ে যায় তো
তোমরা
বাকিগুলো করে
ফাইল
হবে
করবে তো।
একটা নেই।
বাকিগুলোরও তো লাগবে তবে একটা
আচ্ছা আমরা যদি না দিই কিভাবে পারবে? দেবে না? একটা দিই। আমি যেটুকু জানি তাই বলে।
আমার তো লাগে টাকা। না দেবে। আরে close করো। দিবে না।
দেবে না?
দেবে না বলে
তো বলছি তো তাই
তাহলে কাইন্ড রেকর্ডিং ফিক্স দিয়ে দিন। অন্যগুলো দেবে। এটা বলুন।
Yes.
দেবে না,
They kind of record that the petitioners are saying that they are going to file a reply in regard to item number 2 only. Rest of the matters, they are not going to file any reply.
Since my lord issues are same
So you have placed reply today.
in respect of item number 2.
2,
Item number
but
two.
Leading matter.
yes,
Leading matter.
like I am appearing on behalf of item number 8. Rest of the others are also appearing in individual item numbers, but reply is not been filed in any of the matters. Only for item number 2, but I don't know who is appearing for item number 2 in.
You
Right
are not
টু মারা ডাইপিং হ্যাপেনিং।
you are appearing.
Only he is appearing.
So what do you want?
Then logic kind.
Opposition reply has.
You serve a copy to them at least. You serve
আরে
a
ভাব একা একা সবাই একটা করে কপি দিতে পারে। Absolutely, my lord. I should.
Yes.
All advocate of the learned advocate of the state in defined matters, I shall serve copy of the
Yes, you
reply
serve the copy.
in respect of item number 2. Because the
Then
submission,
Lordship, we can come back any other day because without the reply, what they have written.
the perishable goods, my lord. Your lordship knows at least this is the 4th occasion they are paying for adjournment.
No, we are not taking any adjournment.
They have not.
We are not taking any adjournment, my lord. We are
No,
not
no.
taking any adjournment.
Very well, start the argument.
There is
So-
a question of law involved, my lord.
Serve a copy of the reply. If it's a short there, anything next week. But yeah.
First of all, ascertain they will not file any affidavit in other matters. That will be on the record it, my lord.
Mr. Saharai argued that all the matters are connected matters. If one matter is decided, all matter can be
That
decided.
will,
That's
my
why-
lord, that will be
No,
recorded.
that is all. No, it's my prerogative whether I shall file or not. But I shall serve copy of the reply to all the learned advocates in respect of item number 2,
You serve them.
my lord.
You serve them. Come on Monday.
Monday, my lord.
Monday under the same heading.
My lord. বুঝতে পেরেছিস কি বলতে চাইছি?
Monday, Tuesday. Monday is the holiday.
Monday, next Monday is not a
No,
holiday.
not holiday.
So
not
Monday, same
Monday.
position remain.
Monday is the 5th. 5th of May. 2 PM and 2 PM. তাতে কিছু নেই।
এই রিপ্লাইটা 10 কপি জেরক্স করুন।
না, না। 12th,
করে যে ম্যাটারে অ্যাডভোকেট আছে সবাইকে এক কপি করে সার্ভিস করে দেবেন। আর একমাত্র জন্য
5th, 12:30.
Then Lordship, can
12:30.
records that someone from state.
Can it be not 12, but it will take some time so that we can conclude our submission. If it is 12, we can conclude,
12.
my lord. If it is 12, we can conclude our submission. Because only issue involved in this
Okay,
matter.
come on 12 then. No issue.
12.
Please take down. I will take down. Affidavit in reply on behalf of the petitioner
আগে দিয়ে দিয়েছিল।
to the affidavit in opposition of respondent number 4
হ্যাঁ।
in WPA number 23724 of 2023 is taken on record. Full stop. The learned counsel,
কোনটা কোনটা আছে দিয়ে দাও তাহলে ওটা দাও।
no, the petitioner is directed to serve the copy of affidavit in reply upon the learned counsel appearing.
But filed in connection with item number 2. Otherwise,
কি বললাম বল?
WP number may be given, my lord.
A copy of affidavit in reply
প্রথম মনে
as placed before this court upon all the learned counsels appearing for the state in others connected matter, in other connected matters.
My lord.
Full stop. Next para. Affidavit in opposition on behalf of respondent number 4 in connection with WPA 26601 of 2023 is taken on record.
তুই কোথায় আছিস?
আমি তো এই প্রথম একটা আছে তারপর
You file it then. Why you have kept it?
Monday,
You file it thereafter. I will check up.
ওটা সুমনদা বলেছিল।
বলছি না।
But interim order is still my lord 6th. ওদের উপর বলুন। নাম্বারগুলো দেওয়া তাহলে
Affidavit in opposition on behalf of respondent number 4 in connection with WPA number 26318 of 2023 and WPA number 3193 of 2024 are also taken on record. Full stop. Having heard the learned counsels for the parties, it appears that the matters are ready for hearing. Let the matter be fixed on 5th of May 2025 at 12 PM, at 12 noon for hearing.
interim order is still my lord 6th of May.
Very well, I will pass the order on that day.
My lord.
গ্রেটফুল মাই লর্ড।
কাগজটা দিয়ে দাও না আমাকে। কাগজটা দিয়ে নাও না আমাদের কাছে। এই আশিস দা কাগজটা দিয়ে দাও। Thank you.
Call next matter.
I'm not waiting for the state respondent.
আমিও তো বাইরে দাঁড়িয়েছিলাম ফোনে কথা বলছি।
It's 17 and 35 correlated matter.
So before My learned argument, Lordship, we are praying for some time to file a reply in the supplementary affidavit that has been filed by them. This is the instruction that I have received from the department
Last
today
occasion?
morning. Today morning I have received.
No, today last occasion, time has been given.
But
Time has been expired.
but last week many holidays have gone, so most of the officers were not there. Today morning only I have received a message
So
from
you
the department.
supposed to submit on the instructions. What is your instruction? You want to
Yes,
file
I
supplementary?
I want to file my reply to the supplementary affidavit filed by them. One reply has already been filed to the main petition I have filed, and one supplementary affidavit was filed by them. That I have received instructions now. So I will need some time. And my learned senior friend is saying that time was given to us, but probably I would bring this to his knowledge that last many days, many holidays were there. So most of the officers were not available, so I could not avail necessary.
Now, what is the other matter? Item number
Same
issue,
issue
one.
is involved.
Same.
36,
35.
35.
Mr. Shoktipada Kundu.
Okay.
And these two matter may appear in the list.
So how many days? 10 days?
Lordship, 2 weeks minimum, 2 to 3 weeks. Kindly.
But short file involved, my lord.
See, you are daily in the practice. We are new entrants. We need to revise our subject well to argue before you and the Honorable Court. Kindly.
But 10 days time may be given. Otherwise, my lord, this part of the
No,
before
come on. Let the matter be start in May, at least before the vacation.
absolutely.
I'm not standing in your lordship's way, but 23rd. हाँ,
On 20th?
20th. I'm fine with
20th?
that. Yes. Grateful, your lordship.
Ms. Sonal Sila, Nalet, counsel appearing for the state, submit that the state respondent intends to use
Should have done this.
supplementary affidavit in opposition against the supplementary affidavit filed by the petitioner. Let the supplementary affidavit be placed within 2 weeks from date. It has been argued by the parties that a short matter is involved in this matter. Accordingly, the matter is fixed on 20th May 2025.
Same position. One.
Under the heading mention matters. Under the heading mention matters.
Both the
Next.
matter appear analogously.
Item number 35 of today's list being WPA 27966 of 2024 be tagged with this matter as the matters are similar in merit. Let both the matter appears on that day. Within 2 weeks, you place and
I will.
The time
20th.
preemptory, my lord. Otherwise, if this size of the vacation,
no, 20th is the day.
time may be preemptory for filing, my lord, reply to the report.
Yes, I will hand over, sir. If I'm saying in the open court, this holds some value.
Okay.
Record video.
Next.
18 I am for the private respondent.
I am for the state, Lordship.
I am for the petition. Well, this is affidavit. My lord, the petitioner's deceased father, my lord, was the licensee in respect of Fair Price Shop, my lord. And he died sometime in the year 2022, my lord, in the month of October. Petitioner's father, my lord, was married for twice. And the private respondent, my lord, the son of the first wife. And petitioner before your lordship is the son of the second wife, my lord. After demise of petitioner's father, my lord, the nomination was given upon consent of all the legal heirs, my lord, to the first wife, my lord, who subsequently in the year 2023, my lord, died. Thereafter, my lord, now the authority concerned is trying to give the license in favor of the private respondent, who is the son of the first wife, my lord, and I am the son of the second wife, my lord. Now, my lord, I made representation, my lord. Since, my lord, as a legal heir, my lord, I have every right to represent the deceased estate, my lord. Therefore, my lord, I made representation as well as, my lord, legal notice was sent in the year 2024 in the month of August, my lord. That was not considered by the authority concerned, my lord. Since, my lord, I am one of the right, my lord, that accrued by the first wife, my lord, my stepmother, my lord, flows from my father's right, my father estate, my lord, in respect of which I have a right, my lord, to represent and also, my lord, to enjoy the fruit of the estate of my father, deceased father, my lord. That is my case, my lord. That legal notices has not been considered by the authority concerned.
So you are the son of first wife,
Second wife, my lord.
second wife.
Second wife. Now the authority concerned, my lord, is trying to give license, or they have given, my lord, to the private respondent, who is the son of first wife, my lord.
License issued already,
My lord,
not issued.
they are taking steps, my lord. That is my case, my lord.
Our lordship, actually, when the father passed away, the first wife applied for the license. That was way back in 27th of December 2022.
License granted.
Till date, the license is not granted, but the application for appointment on a compassionate grounds was made in way back.
No, that was granted in favor of Sobhita Mon. Asking for Sobhita Mon. My lord is
That is the first wife.
First wife, my lord.
First, so license was granted to the first wife
yes.
after demise of the earlier
Yes.
Emma dealer.
Yes, my lord.
So whether first wife was running the business.
Yes.
Yes.
And then thereafter first wife died. Now, my lord, they are not entitled. They are not the legal heir of
Yes,
Sobhita Mon.
they are not the legal heir of Savita.
Because, my lord,
My lord.
when, my lord, may I please? The license initially was in the name of Bhadrashwar Mon. Now, after death of Bhadrashwar Mondal, the license was given in favor of Sobhita Mondal.
Yes.
Now, my lord, I placed the relevant provision under the compassionate ground. No objection. In fact, no objection is not
Yes.
required. So, my lord, after the death of Sobhita Mondal, now the legal heir of the Sobhita Mondal are entitled. Not
Applied
the
for license on compassionate.
Yes. They have applied, and my instruction, they are on the verge of completion only because of this petition, because they are trying to put some hurdle so that the license is not.
This is important. And actually they had the claim. At that very point, there was no application. The application was made in 2024.
And there is a strict provision within 60 days that application has to be made. And they are not entitled to make any representation because no right accrued in favor of them.
My lord, my right is there, my lord. I am the son.
When? How your right accrued?
My lord, I am the son, my lord. My lord,
Yes,
kindly
you are
see,
the son, maybe.
my lord,
Where is
see
your
the
right?
page number 14
Whether
and
you are son
15.
of Sobhita,
My lord, I am son of Chaya Mondal, my lord. Second wife, my lord.
forget
My-
about Shayamandal. The license was issued in favor of Sobhita.
My lord, the license originally belonged to
No,
my father,
originally
my
it's
lord.
not there. Already license was granted
My
on
lord,
compassionate ground.
that was in the name of my father, my lord.
No,
That is
not your
my
father.
father's estate, my lord. That is.
No.
My lord, kindly
You don't
consider,
have
my
any
lord.
right.
My lord,
No.
kindly consider page
You
number
are not a
14,
family
the
member
legal heir
of Sobhita.
certificate, my lord. 14 and 15, my lord, kindly
You
consider
are
once,
not
my lord.
a family member of Sobhita.
My lord, Sobhita Mondal has got the right through Bhadrashwar Mondal, who is my father,
Whatever
my
may
lord.
be the right has already been accrued and the license has already been granted.
My lord, only one person, my lord, nomination has to be made by the family members in favor of only one person. And she was the eldest member in the family. For that reason, my lord, she
No,
was.
not that reason. Sobhita Mandal being the wife, not required to file any NOC.
NOC.
My
This
lord,
is the law.
my lord, even after that, my lord,
No,
my
how can
right
you,
cannot
how
be
can
taken.
you plead your right in
My lord,
respect of Sobhita Mandal?
I am the son of the.
Whatever maybe you are the son,
This
but
is
you are
by
not
the
the son of
licensee.
Sobhita. You show me your right. Whether
Being
you
the son, for the purpose of
you,
argument,
yes,
my
I
lord.
understand your service. Bhadrashwar Mandal has two wives.
Yes,
Okay.
my lord.
So Shobita Mandal and Chaya Mandal, two wives are there.
Yes.
Thereafter, some sons are there. Forget about the right of the wife, whether legitimate or illegitimate. Forget about that. But you, being the son,
My
have
lord,
the
I
right.
have a right.
But when Shobita Mandal applied for license,
My lord,
no
from
required
the
for-
family, one person, my lord. I have
no, not one person.
Yes, my lord. Paragraph number 6, I have made out
They have
that
stated
case,
the
my
law is
lord.
different.
No, you you know the law. You
My
don't
lord,
have any right.
cannot take away the right of a son, my lord.
The son has
The
no right.
property of in the property of
Son has
other,
no
my lord.
right.
My lord, only one person will be given, my lord, the
Yes,
license. My
this
lord,
is the law.
kindly consider that is the law, my lord. Kindly
Yes,
consider paragraph
if-
number 6 at page
No,
3.
you see the law. The if wife file an application for compensation payment, no requirement for other is there.
My lord,
Because
wife.
of the fact that
Yes,
wife
no
has given
objection.
the-
So far, the no objection, filing of no
not
objection
no
is concerned,
objection.
my lord. That is not required under the law,
Not
under
no
the
objection.
rules, my lord.
No.
Now the
You just
question,
hear it.
my lord.
This is not no objection like that. Because of that, the wife inherit, and the wife is under the condition
wife,
that
rule
that's
cannot
why
take
the
away
wife
my
given the
statutory
to
right, my
apply
lord.
alone.
My lord, rule cannot take away my right being the son, my lord, of
Rule is there.
my father's estate,
Rule
my
is
lord.
there.
My lord, rule is there if that is contrary to the statute, my lord.
No, statute is
My
there.
lord, my lord, I am the son, my lord. One person has to be nominated, my lord.
Very good. Yes, when Shobita Mandal was given the license?
14 July 2023.
14th July 2023. When he, Sabita.
Yes.
When Sabita expired?
The prior
My lord, 29th October 2023.
This is the death certificate and other copies.
29th October 2020.
This is the death certificate of Shobita Mandal.
What is your prayer in the repetition?
My lord, one in the issue license in favor of the petitioner, and prayer B, my lord, to consider the legal notices, my lord, that is 6th August 2024 and 30th August 2024, my lord.
Sixth August as page 26.
My lord, page 26, my lord.
Okay. Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. One Bhadrashwar Mandal, since deceased, was a proprietor of fair price shop being FPS number 13380070024. Full stop. The Bhadreshwar Mondal expired on 1st of October 2022. Full stop. Next paragraph. It is the contention of the petitioner that Bhadreshwar Mondal had two wives, namely Shobita Mondal within bracket first wife and Chaya Mondal within bracket second wife.
My lord, I have annexed the legal year certificate at page 14
Yes,
and
got
15.
it.
my
Through first wife, Bhadreshwar Mondal has three legal heirs, namely Samoli Khetropal, daughter, Samol Mondal, son, and Pompa Malik, daughter. Full stop. Through second wife, he has only legal one son, namely Sudip Mondal, the petitioner. Full stop. It is the contention of the petitioner that after demise of his father, the license was granted to Shobita Mondal, being the eldest member of the family. It is the further case of the petitioner that that Shobita expired on 14th of September 2023.
Not 14th of September, 29th of
14, Shobita expired on 29th of
October.
29th of no stop 29th of October 2023. After his demise, the private respondent applied for license. It is the contention of the petitioner that he, being the son of Bhadreshwar Mondal, entitled to get the respective shares of his father's property. Thus, he is entitled to receive the license. The petitioner has filed two representations on 6th of August 2024 as well as 30th August 2024 to the Subdivisional Controller Food and Supply Concern SCF. But but none of his representation was considered. Hence this writ. Ms. Amrita Paja Maulik, Learned Counsel, appearing on behalf of the state, submits that after demise of the erstwhile MR dealer, namely Bhadreshwar Mondal, the license was granted in favor of his wife, his widow, Shobita Mondal, on 4th of September 2000. 14th of September. 14th of July.
2020.
14th of July 2023. Full stop. According to the provisions of control, see further submits that according to the provisions of control order, as no NOC certificate, NOC certificate, no
submission.
no objection certificate, NOC, no objection certificate is required for the widow of a MR dealer. Thus, the license was granted in favor of Shobita Mondol. Full stop. She further submits that Shobita expired on 29th of October 2023. After that, the private respondent has applied for license on compassionate ground. The procedure for consideration of the application by the private respondent is yet to be disposed of. Full stop. It is the further contention of Mrs. Paja Maulik that the present petitioner has no right to apply for the license on compassionate ground. The present petitioner is not a family member of licensee, namely Shobita Mondol. Hence, the instant writ petition has no merit to entertain. Learned counsel appearing on behalf of the private respondent number 4 submits that the that his mother Shobita Mondol
5, my lord. Private respondent number 5.
5 submits that থাকবে 5 করো প্রাইভেট রেসপন্স নাম্বার 5 করো উপরে উপরে কোডটা কেটেছো জাস্ট উপরের লাইনটা 5 বাকিটা কেটে দাও কি বললাম private respondent number 5 submits that after demise of his father, the license was granted in favor of his mother Shobita Mondol. After receiving the license, his mother was continuing the business. During the subsistence of her business, she expired on 29th of October 2023. He submits that the present petitioner is not a legal heir of Shobita Mondol, hence his right, hence he has no right to file the instant writ petition. Having heard the learned counsels for the parties and considering the submission of the petitioner, it appears that the admitted fact of the instant matter is that the erstwhile emmer dealer Bhadrashwar Mondol has 2 wives, namely Shobita Mondol and Chaya Mondol. The present petitioner is the son of second wife and respondent number 5 is the son of first wife. Full stop. In considering the right to file an application for compassionate ground, clause 20 subclause 6 of the West Bengal WPDS maintenance and control order has specifically subclause 20 subclause 6 2013 enumerates লেখো করবে এই পাঁচটা করবে in case of death or in case of incapacitation, page 1.20, just last paragraph. From the said provision, it appears that to file an application for getting license on compassionate ground, the family members of deceased dealer has the scope to file the application. Full stop. The term family member has described or defined in clause 2 subclause M of said control order 2013 as follows. M family members করবে এই এটা করবে clause 1.9 পেজ এই যেরকম লেখা আছে M ঠিক আছে In the family member, in the list of family members, clause M within bracket 3 denotes son as son includes son legally adopted before death or incapacitation. Full stop. The term son does not include the son of second wife or illegitimate son. Full stop. Moreover, it appears in this case that the license of Bhadreshwar Mandal was granted in favor of his first wife Shobita Mandal. When the license was granted in favor of Shobita Mandal, all rights arising out of demise of Bhadreshwar Mandal has wiped out. Now, if we consider the application, if I consider the right to apply for license of the petitioner, it appears to me that the petitioner is not truly come under the definition of family member of Shobita Mandal. Clause 20, subclause 6 of Control Order 2013 denoted that in case of death of a dealer, the dealer means and includes in this case is Shobita Mandal, not Bhadreshwar Mandal. Thus, thus after considering the all prayer and submissions and pleadings of the petitioner, it appears to me that the petitioners have no right to apply for license on compassionate ground, which was granted in favor of Shobita Mandal. I make it full stop. Next, but I make it clear that the petitioner may have right to apply for license on compassionate ground after the demise of earlier ration dealer, earlier MR dealer Bhadreshwar Mandal, but as he not chose to apply for the license on that relevant point of time.
They applied, hearing was given, but they have given consent for appointment of Shobita.
Okay. কি বললাম বলো?
তাহলে clarification না থাকলে আবার
He has given consent. He
Yes.
has given consent for granting license in favor of Shobita Mandal. The petitioner appears to have waived his right. At this juncture, I find no justification to entertain the petitioner. Accordingly, the instant writ petition is dismissed and disposed of.
Grateful.
Next.
19, I'm appearing on behalf of state, respondent number 2, but I feel here the answering respondent is respondent number 3, 4, 5.
I'm for Union India. Answer respondent is my lord.
3,
Where is
4,
the-
3 to 5.
Where is the petitioner?
Petitioner also is not here.
Hmm?
Tender matter, Lordship.
Jute Corporation of India.
Yes.
You are representing Jute Corporation.
No, no.
Union of India.
Union, who is Jute Corporation?
They are not representing. As of now, they are not representing.
And you are appearing?
State, respondent number 2. He is for 1, I'm for 2. But 3 to 5 are the answering respondents, Lordship. I don't find they are appearing.
Don't know whether they are served or not also.
However, no one is appearing on behalf of the petitioner. None appears on behalf of the petition. Let the matter go out of the list. Next.
Great.
I appear for the petitioner, my lord.
I appear for the state respondents.
Lordship would recall, my lord, on the last occasion I had submitted that the cost title was incorrect, my lord, in as much as, my lord, the address of the district controller was incorrect, my lord. We've served them, my lord, and my learned friend is appearing for the state. In respect of, my lord, all, my lord, the earlier ones and the latest.
Yes, what is the matter?
My lord, the matter, my lord, pertains to, my lord, stay of vacancy notice, my lord, but this is under the 2024 control order, my lord. Well, I'll be candid, my lord. I have today, as of now, my lord, I'm not pressing for any interim orders. All that I would beseech your lordship, my lord, is to request my learned friends, my lord, to at least, my lord, file a report, my lord, so that it can be clear, my lord, whether at all any card is being delinked or not. Because this has happened in, my lord, since I'm appearing in a lot of matters. 30% of the matters, my lord, when the opposition comes, it is seen that, my lord, my card is not being detagged. So perhaps, my lord, I will not even pursue this, if that be so, my lord. So only a report if it
Report
could
or
be
one,
filed.
I shall come with an affidavit proper.
If you want
Put in the form of affidavit, since I'm not pressing, I want a short date, my lord, since I'm not pressing for, if they
short date, whether it is possible before vacation.
Uh,
a vacation,
Just,
vacation long time to go, my lord.
long time now.
If you,
No,
if you want
it is
to
the
file a
representation.
report, then you have to give in a reply like that.
No, my.
That's why at least 5 weeks.
No, my lord. Lordship,
That means
There is
3
a
and 2.
representation.
I'll
If
tell you,
that is
lordship.
directed to be disposed
Regularly,
of,
what is happening there here? 3 and 2. That is the option we are usually taking.
That is correct, my lord. But I'll tell you, my lord, what practically happens, my lord. Lordship, my lord, gives them 3 weeks, my lord. The affidavit would be affirmed if your lordship sees, my lord, just 1 day before the date of expiry. If it's 2 weeks, 1 day. For me also, my lord, if your lordship gives me 2 weeks time, my lord, it is always a day before that we affirm. 1 week, again a day before we affirm.
So within 1 week, you can file the reply.
No. What I'm
if you want
I do not
earlier
even-
disposal, my lord, there is a representation, his allegation is that has not been replied to. We shall reply to the representation within a given time. That will shortcut the matter. If your lordship so directs, that is also, yes.
You are not aware whether your cards were detected or not.
No, detag. But what I'm saying is, my lord, all that I would want, my lord, since it's a 2024 notification, so my lord, I'm not even depending on the orders passed by the division bench. And I'm not, as I said, my lord, as on date, I will not press for any interim orders also, my lord. The reason being, the only reason being, I want them to come up with a report, but not on all the points. Only in respect of, my lord, the cards that would be dealing, my lord, one. And second, my lord, if there is any other vacancy notice in respect of, my lord, the same area to which I am catering or not. That's
So
the only
let
2
them
points.
consider the representation. Your
Yes,
representation.
that's what I was saying.
No, my representation, again, what will happen?
He has,
Lordship,
he has,
we know
again,
the
what
fate.
he has ventilated his grievance
I'll
in
tell you-
entirety. Let, if that is considered within a given
If I
time,
direct them to consider your representation within a very short period, that will
No,
be
what will
suffice.
happen, my lord? What will happen is that will, my lord,
Please
my lord,
go to page.
consequence would be multiplicity of proceedings, my lord. Because
why
I
multiplicity?
am sure, they are sure, and even your lordship knows, my lord, representation
6th of
ultimately
March is
would
the
be.
representation, 6th of March 2025. And it's about 5-page detail, his grievances have been made in detail.
So can you within 2 weeks can you give him the reply?
Not 2 weeks. At least 3 weeks be given, we shall dispose it of.
No, my lord, that
So
will,
that I can hear about the matter. If he are aggrieved with your decision within the May, that's why I am wanted to dispose of his representation within 16th of May.
no, 16th, keeping the writ petition alive, then it will not serve purpose because I will have to come back and file a writ petition once again. That will, my lord, that will, my lord, give rise to multiplicity of proceeding, and second, my lord, it would not be cost effective for the clients, my lord. As it is, they are suffering.
Very well. So within 3 weeks you can file the affidavit in opposition, and within 1 week you file the
But
reply.
I was not pressing for any interim orders for the sole reason that perhaps within a week's time, if
If
they file that,
if I direct them to file a reply within a week,
It will not be done. I'll come again and pray for
they
extension.
cannot, in 1 week, they will not be able to find out whether they are, what are the number of
No,
cards
no,
that they
no,
have
it's
intact.
not possible.
for them.
It's not possible. It's
It's
a
not
government.
possible for them.
I'll intimate them.
Not that, my lord. I'm
Which
also in the
district?
state
I
panel.
don't
my
know.
lord.
Kun district?
I'm also in the state panel, my lord. It is about how hard you press.
This is Purba Bardhaman.
It can happen in 24 hours also, my lord. It is all about how hard you press. Well, I'm not on affidavits, my lord.
No, just सबको बोलते दें.
They can give a so that, my lord, just before the vacation, if it could be heard, my lord. That's it. That's my
Very
only prayer.
Very well. Please take down.
My lordship is keeping it this side of the vacation.
Yes.
Deeply obliged.
Having heard the learned counsel for the parties, it appears that the matter cannot be decided without giving opportunity to the petitioner, to the respondent authorities to file a report in the form of affidavit. Let the report in the form of affidavit be filed within 2 weeks from date.
2 weeks. Okay.
Within 2 weeks from date, reply by the petitioner within 1 week thereafter. List the matter under the same heading on 20th May.
Well, I will take 3 days. So lordship can shorten it. I'll just take 3 days.
So let us have.
Whatever
3
may
days.
be, it will
Let him
come
take
on
3
19th
days.
or 20th.
Sir, can you
19th or 20th.
Huh?
Not better before that.
Lordship kindly records that interim order is not as prayed for. Interim order is not granted as
Because-
prayed for.
Yes, yes,
He has prayed for no interim order. Let that be recorded.
Okay.
Yes, in entirety, not prayed for,
Not
because he has
because you
prayed
have
for a
prayed
short
for-
time,
Is not.
so that the report could be filed within a short time, the matter could be heard.
The petitioner petitioner submits that at present he is not pressing for an interim order, but
Yes.
he intends to argue the matter on report of the state respondent. তারপর কি বলেছি?
And therefore has prayed for a short time. Yeah, otherwise, my friends,
আরে এত কিছু বলার দরকার নেই জসের
Yes. ঠিক আছে, ওইটা ফার্স্টে করুন তারপরে এটা।
lordship will kindly, and has consequently prayed for a short date. Only this much. Because that,
You have prayed for short date, that's why I have given the short date.
let that be recorded, my lord. Since,
No, not required.
since your lordship is recording that I am not pressing for interim orders,
Okay,
the reason is that I am praying for a short date.
Regularly, I am giving the 3 weeks and 5 weeks, and in your case, it will 3 weeks. Only 3 weeks given. 2 weeks, 1 week. So what is mean?
Lordship will give me 1 week or 3 days. 1 week.
1 week.
So lordship has kept
1
it on.
week means you have only 3 days. If we
I don't mind,
count,
lord.
if
I
we
will not even
count
file.
30th, 29th of this day being the 2 weeks, it will appear when? 1 to 15. 15th of May.
The matter will appear on 15th of May.
No, 15th of May is the 2 weeks
Okay.
ending. Thereafter, you have only 3 days. That we are taking this matter, that is Sunday and Saturday is there, 2 vacation. Thereafter, Monday is the 3 days, and Tuesday is the date, 20th. Practically, you have only 3 days.
The lordship will not record that I have prayed for a short date. No.
I have given you short date.
Kindly record this, my lord. Kindly record this.
What is the purpose?
Then what is the my lord? There is purpose behind everything. My lord, friend, my lord, being a senior, my lord, he knows what happens, my lord,
No.
later on. So he is, my lord, very tactfully got it recorded.
I also understand.
Yes, lordship knows. I
can also
appreciate that.
understand.
As an advocate, I appreciate that, my lord. So tactfully recorded that I have not prayed, my lord, but I have, the reason was that I said I will not pray, and I had requested for a short date, which lordship has given. So lordship kindly only records that he has not pressed for any interim order and has prayed for a short date.
Day when the matter will appear, if they not place the report, so that you can argue on that point that they have given the short date, but I can argue for the interim order. That will be your submission on the next day, 20th.
Yes, so Lordship kindly record me and let's wait for a short.
Required, you can argue on that point. I
Hope the
understand.
determination does not
Yes,
change. Obliged.
not required to.
I just hope that the determination does not change. Otherwise, it will
I
be
can
very tough to
understand. I
explain
can.
to the new judgment who comes in.
Yes. Next matter.
My lord.
21, my lord. I am for the petitioner, my lord. My report has been filed. Exception is ready. My client, the petitioner, is not feeling well, could not come to court.
This is
my
my
lord.
report.
So I am bringing note this week, my lord, so that I can affirm and file before lordship.
This is my report, my lord. We have served already.
Yes, I got it. My exception is ready also.
The report in the form of affidavit filed on by the state respondent is taken on record. Petitioner seeks time to file a reply.
Exception to the report.
To the report. Exception to the report. Let the exception be filed within a week. List the matter under the same heading on May 7th.
May 7th.
May 7th.
Thank you, lord.
My lord.
Next.
The copy of the report we kept to the record. Yes.
From 22 to 24, then 26, 35, and 40. Mr. Suman Sengupta was supposed to argue before your lordship, my lord, on this in this matter. My lord, he's on legs before courtroom number 37. But he has requested me to seek an adjournment on his ground, my lord. 35 লেখা ছিল, দেখে নিচ্ছি আমার 35 হয়ে গেছে।
35 17 সাথে হয়ে গেছে।
হুম? আছে তো। হ্যাঁ।
So you supposed to argue on the point of maintainability.
My lord, he was supposed to argue on the point of maintainability.
Yes, you start the argument.
Lord, he was supposed to commence his argument, my lord.
Today,
my lord.
Yes.
So he is in some difficulty, my lord. Kindly keep it tomorrow, my lord. He'll address your lordship.
You are competent enough. You can
My lord,
start.
I may be, my lord, but Mr. Sengupta, my lord, has requested me to take an adjournment. My lord, if tomorrow he does not come, my lord, I'll begin argument.
Tomorrow, why tomorrow? Why not today? Take some Passover.
But kindly pass it over, my lord. Then I'll indicate your lordship's observation, my lord.
Yes. Because this matter is running in the list for quite days.
My lord.
Yesterday, also they took
Yesterday, my lord, it was
So
indicated that the matter will be fixed at
23, 24 and 26
22, 23, 24, 26, and 40, my lord.
and 40.
40, my lord.
Very well. I'll take up all the matters.
My lord, it was indicated by your lordship yesterday that the matters will be taken up at 12:30, my lord. Kindly keep it at 12:30, my lord. I'll indicate Mr. Sengupta. And
This is right, my lord. This is
Yes, yes.
12:30 lordship.
I'm grateful, my lord.
Call next matter. 25. Who is for the petition? None appears on view of the petitioner. Let the matter go out of the list. 27 ডাকুন।
কি হলো? Order হলো?
For the petition. So you said. Offered by your lordship judgment as affirmed by the division bench is my affidavit of service. Lord, Hindustan Petroleum Corporation Limited quoted e-tender for engagement of transporter for transporting bulk petroleum product from ex-Morrigan top. Lord, kindly turn to page 27 of my petition. The notice inviting tender. Tender date right hand side top 20th September 2024. Have you also got my lord? Page
Hindustan
20,
Petroleum Corporation Limited.
page 27, P1. Right hand side top, it has been notified on 20th September 2024. Then serial number 5, tender due date and time 11th October. Have you also got after 4-5 line?
Tender due date and time.
11th October 2024. Now you'll also kindly come to page 38. This is the bid documents I have annexed, page 38. You'll also may straight away come to page 112, one of the condition. 112. General terms and conditions. At page 112.
Yes.
Kindly come to clause number 6. For tank trucks under operation with any other oil company, an unconditional no objection certificate is to be obtained from the concerned oil company for placing the same fully in the service of the Hindustan Petroleum Corporation against this tender. NOC is to be submitted at the time of induction of the tank truck. The condition is that even my offered entities are at present running with any other oil company or engaged by any other oil company. I can offer the same also, but at the time of induction, I have to submit the NOC from that oil company. So, offering entities owned by me without not attached with oil company, and it can also be attached with other oil company. But the condition is that last line, NOC to be submitted at the time of induction of the tank trucks.
Yes.
But induction means, my lord, first offer letter, then acceptance, then deposition of the security money. Thereafter, my lord, I have to place all the vehicles, then agreement will be executed. Then, my lord, induction. Induction means, my lord, color change and other things are concerned so far the specification of the HPCL is concerned. Color change, locker system, truck system, these are the all induction. Now, your lordship, kindly come to the next page. Not next page, my lord. Kindly 3-4 paragraph of my petition, paragraph 6, page 6. Just case which I have made out. Admitted position, my lord, in the tender documents, I have disclosed 8 TTs. Out of that, my lord, 4 TTs are attached with the IOCL. 6 TTs were attached and 2 are free. Admittedly, they will show, it will appear from their documents also. But in the application form, although there was no extra privilege or benefit, I have recorded that all the TTs are free. The reason for such, I shall read from paragraph 6, my lord, for this reason, paragraph 6, page 6.
What you said, the all TTs are free.
Yes, I have disclosed as all TTs are free. Why I am saying so, kindly take paragraph 6. Your petition states that subject e-tender had been floated by the oil company by e-tender notice dated 20th September 2024. And your petitioner wanted to participate in the said tender process by offering 8 number of own TTs. However, at that point of time, since phone number of own TTs being TT number so and so, out of 8 number of own TTs of your petitioner were engaged with Indian Oil Corporation Limited, your petitioner to participate in the said tender by offering all 8 free TTs immediately after publication of such advertisement dated so and so. Your petitioner filed letter dated so and so requested the IOCL authority to release the 4 TTs of your petitioner by way of issuing NOC, so that your petitioner could offer all TTs free TTs in the said e-tender floated by the HPCL. Your petitioner further states that after such email dated 30th September 2024, I have shown to your lordship 11th October 2024 as the last date. Your petitioner number 2 herein personally approached the IOCL authority and the concerned official of the IOCL with no uncertain have assured your petitioner number 2 herein that all those 4 TTs attached engaged with IOCL would be released within 7 days. Your petitioner states that despite such specific assurance by the IOCL authority that all 4 attached TTs would be released by IOCL, since despite completion of almost all formalities, TTs would not be released, your petitioner number 2 herein again met the concerned officials of IOCL on 9th of October 2024 for immediate release of those 4 attached TTs, while the concerned official told your petitioner that all formalities, including approval from higher official, has already been obtained and all those 4 attached TTs shall be released on so and so, 10th of October. Your petitioner states that since the official of the IOCL rest assured your petitioner number 2 herein that in any manner 4 attached TTs would be released on 10th of October 2024, your petitioners being an eligible candidate pursuant to such tender of HPCL had submitted their bid through email on 10th October 2024, that is just before the last date of such application. But in that application, I have admittedly released that all TTs are free, although on that day 2 TTs are free and another 4 TTs are attached with IOCL. Your petitioner states that after submission of such e-bid, since your petitioner did not get any communication from the IOCL authority releasing their 4 attached TTs, your petitioner number 2 on the very same day on 10th October 2024 again met the concerned official of the IOCL, while your petitioner number 2 herein had been told that due to some technical problems, IOCL authority could not release your petitioner 4 number of technical TTs. After coming to learn such fact, your petitioner number 2 immediately made a request to the IOCL authority through email requesting them for issuance of NOC of those 4 attached TTs so and so. Xerox copy of the email. Your petitioner states that since the concerned official IOCL with no uncertainty have assured your petitioner that NOC of the 4 TTs must be issued by 10th October 2024. Accordingly, your petitioner, believing such assurance, disclose all their 8 offered TTs in the bid document as free TTs. Otherwise, if petitioners disclose those 4 TTs as attached to the AOCL, in that case, for suppression of facts, a petitioner bid may be rejected. Your petitioner states, but the further state the situation beyond the control of a petitioner forced them to disclose attached TTs as free TTs with total bona fide intention, and the for such bona fide suppression, petitioner did not get any extra benefit. Your petitioner states that after submission of the bid pursuant to so and so, and after opening price bid in respect of so and so, your petitioner had been selected as successful bidder in respect of tender, and total 6 numbers of TTs have been selected. Your petitioner further states that selected as successful bidder in respect of the said bidder, your petitioner filed email dated so and so again requested the IOCL to release those 4 TTs numbers so and so. In response to the said email dated so and so, despite having knowledge of the IOCL authorities, filed mail dated so and so directed your petitioner to provide, supply, intimate the reason for NOC. Then, my lord, I have intimated the NOC. I shall show from the documents. Then, my lord, I have been selected and offer letter has been issued. Now, your lordship, kindly come to page 260 of my petition. Well, this is the first email I have intimated to the IOCL authority, 30th September 2024 at page 260. And I have shown to your lordship the last date of submission of application on 11th of October.
260.
260. Annexure P2. Have you got my lord?
Yes.
Well, this is the email addressing to the IOCL authority. Kindly see the last line. So we request you to please look into the matter and do the needful. Business is not going properly. Then kindly come to the next page. Well, technical bid documents I have annexed on 10th October 2024. Then you should kindly come to page 378, the other emails, 378. On 10th October, I have submitted my application through email, disclosing therein that out of offered 8 TTs, all are free TTs. On 10th October, since the NOC has not been granted, I made a further email to the IOCL authority. Kindly see the last line at page 378. So we earnestly request you to release, give me NOC of our below mentioned TTs, these 4 TTs. Now, by the next page, the IOCL wrote to me on 17th October 2024. Kindly see middle portion. first line, my lord, kindly please give me the NOC, follow TTs, and then my lord, middle portion. NOC for what reasons? Kindly confirm. Have you lordship got, my lord? NOC for what reasons? Kindly confirm. This is, my lord, 17th October. On 24th October, my lord, I intimated them the reason for such release, and once again requested them the next page, page 380, to release the TTs immediately.
Yes.
And give me NOC at page 387. Then kindly turn, my lord, page 382. This is, my lord, offer letter, provisional letter of acceptance. Award has been issued in my name on 18th of December 2024 at page 382. My lord, kindly take note of the first box, 12 KL to 18 KL, 4 TTs, and 18 KL to 25 KL, 2 TTs. Total, I have been selected in respect of 6 TTs. And the instruction in the next page is, my lord, page 383, serial number 1. Kindly submit performance security of rupees 8 lakh. So far I am concerned, my lord, since I have not a civil cast or civil trial, 8 lakh is gone to me in the form of demand draft. Then 3, please bring the original documents of owned attached tank trucks offered in his tender as given below our verification so and so. Then 5, you are required to complete the above formalities within 15 days from the date of booking of the so and so. This letter I have received on 2nd of January 2025. I have recorded, my lord, in para 3 by page 10. Although it is dated 18th December, but I have received it on 2nd of January 2025, para 13, page 10, I have recorded. Then kindly come to, my lord, page 385. The bank guarantee. Within 8 days from the date of receipt of the offer letter, I have deposited, my lord, kindly see the bank guarantee at page 385. The next page is the bank guarantee, copy of the bank guarantee in the name of Hindustan Petroleum Corporation, page 386. 386. Then, my lord, kindly turn to page 389. Again, I have written letter on 7th February prior to execution of agreement. Please hand over the NOC at page 389 to the IOCL authority as soon as possible. Then, my lord, kindly come to
Yes.
page 404. Page 4034. 404. But there are 2 pages numbered as 404. You'll have to kindly see the first one, and it's just B10. But a show cause notice has been issued on 25th of March 2025. At page 404. This is with reference to cause notice so and so bulk petroleum. This is with reference to the provisional letter of acceptance so and so against the following 6 TTs. Consequently, a bulk petroleum product road transport agreement has been executed. Kindly see, my lord, last paragraph. 11th February 2025, agreement has been executed with me. Transport was annexed between so and so. After signing the above transfer agreement, by your letter so and so, you have confirmed that all the above TTs offered by you ready to take load. The next page, my lord. It is pertinent to note that you have submitted a declaration in the tender documents so and so, wherein you have confirmed that none of the 6 TTs offered by you are running under any other transportation contract with any so and so. Then second paragraph. Hence, the corporation approach Indian Oil Corporation Limited.
You are reading page?
Page 40. Next, there are 2 404.
Yes.
Second 404, second paragraph.
Yes.
Hence, the corporation approach Indian Oil Corporation Limited, IOCL, Morigam, for induction of your 6 TTs in their system for taking MS so and so, informed that the following 4 TTs, well, 4 TTs have been attached with the IOCL that has been interpreted by the IOCL company. Then, my lord, kindly come to 407. I gave these are the, on 27th NOC has been granted to me by the IOCL. This show cause notice has been issued on 25th March. On 27th March, NOC has been given in respect of all 4 TTs, and at that material point of time, question of induction even does not arise. They have never intimated me for induction. Prior to that, NOC has been issued by the IOCL at page 407. All 4 TTs. Now I gave a detailed reply. So far the show cause notice is concerned at 408. Well, I should kindly take pain to go through some paragraphs. This is 5th April 2025. Pursuant to the e-tender floated by your oil company on so and so for transportation of bulk petroleum product Morigam, our partnership have participated. Then next paragraph. By the said LOA dated so and so, we have been instructed to deposit a sum of rupees 8 lakhs, security original documents of all 6 cities. Pursuant to such instruction, we have submitted bank guarantee of 8 lakh as performance security and also placed 6 cities physically for verification and also produced original copies of documents in all Solomon. All 6 cities have been placed before them. Subsequently, as per instructions specified in HPCL branding sticker, has been levied in all 6 offered TTs on payment of required fees to the company authorized by the HPCL, and on third-party inspection has been conducted. Out of total 6 offered TTs, 1 TT has started functioning at Morigam top, and another TT to 1 TT is going to be after. Now 2 is functioning. In the aforesaid backdrop, on 25th March 2025, we have received an email on so and so issued from so and so show cause notice, referring some clauses so and so. Then paragraph starts. Fact remains that the subject e-tender has been floated by your oil company on so and so, and immediately thereafter on 3rd September, entire fact I have shown to your lordship. Why and what prompted me to disclose the 4 attached TTs as free TT, in addition to the 2 free TTs that I have categorically stated in my show cause reply. You will kindly go through all emails I have annexed.
Yes.
Then page 411, last but one paragraph. We had and or have any malafide intention to suppress the conceal or manipulate facts and misrepresent, but there may be a little mistake, rather misunderstanding with bona fide intention. Accordingly, we do hereby request you to allow us to place our all 4 offered TTs and indicate so and so, and allow to load petroleum product. Before parting, we once again request you to consider the entire episode, which prompted us to release, declare that none of the 4 offered TTs are running under any transportation so and so. Mistake, if any, is bona fide on part so and so. But for that, I have not given any priority. For disclosure of TTs attached with other oil company or not attached, they never carries any marks or any priority. So I have not gained anything. They have also not suffered anything. For declaring my 4 TTs, PTTs instead of my attached TTs, there is no extra marks or extra facilities or extra priority, nothing. And they have also not suffered anything. Why I am saying so? Because date of induction has not yet come. We have already received the NOC. Now, your lordship, kindly come the next page. Page 413. The minutes of the hearing. Well, I'm reading 1, 2, 3, 4. Yes. Transporter reiterated that they did not declare that it is in OMC contract in tender document under the impression and verbal assurance from the IOC that they will give NOC. However, when they approach IOC for NOC after receipt of so and so, got verbal information from IOC that there will be TTs are already released and NOC will be issued shortly. Transporter who produced NOC dated manner I have produced, that has also seen, issued from IOC from participation in any other OMC tender. This was already enclosed with their response dated 5th April 25. They also submitted that they have already completed all the formalities, including branding and inspection, and made all the TTs ready for so and so. Based on above fact, they requested for showing leniency by not remaining so and so. Now the order of termination at page Myler 414. Your lordship, kindly turn to a page. What is the punishment? Kindly see. At page Myler 416. Last part, 3rd paragraph I am reading. Therefore, we have terminated the transport agreement under clause 22D and F of the transport agreement blacklist also on blacklisting 6 TTs. Numbering has been given, all 6 TTs. 2 always free, that is functioning, that has also been declared by alert, blacklisted. Yes, with effect on so industry-wise, or paragraph so and so. It will kindly take note of my alert, these clauses 8.2.14, 8.2.2.15, 8.2.2.16 of the transport discipline guideline, and for forfeit your security deposit. 3 punishment, my lord. All 6 TTs blacklisted. Agreement has been terminated. Security money has been forfeited. In respect of 2 TTs which has never been attached to it, any that has also been declared, my lord, forfeited. Now, your lordship knows, my lord, the similar issue, identical point has been considered by your lordship, and judgment had been delivered. Just I am basically, your lordship, my learned friend also knows the same. Even then, I'm handing over a copy. Just one your lordship's judgment, then I shall produce the, my lord, division bench judgment. Paragraph page 30. In that matter, your lordship has released all the page 13, last paragraph. And the operative portion, 3-4 lines. Then operative portion, page 14, third paragraph. Page 14, third paragraph. Your lordship has quashed and set aside. This is in respect of IOCL. Now the IOCL preferred and mandamus appeal.
That is in respect of not placing the cards.
Yes, madam.
Cards.
Yes. What
But
is the
in this matter, you have admittedly
Yes.
submitted
What
application
what
stating
what
that
the-
all TTs are free.
What the division bench says, kindly take note of it. This is very important. Paragraph 19, page 11. Whether for that, my lord, suppression of facts. My lord, only charge is suppression of facts. You'll also kindly come to page 11, paragraph 19. May I read, my lord?
Yes.
The aforesaid clauses make it amply clear. Mere submission of a forged false information. Kindly take note of. This is the only charge against him. With regard to one or some of the TTs would not ipso facto lead to terminate the contract as a whole or blacklisting of the entire fact. It must be borne in mind that an order of blacklisting on an industry basis would tantamount to commercial death of the contractor. Thus, this extreme penalty is reserved for those injurious cases where the oil company is able to establish complicity of the contract in the multi-parties. The word complicity means active connivance or participation in wrongdoing or a crime. Can you take note of? That is, say that fake document or false information relied upon by the contractor must be used with requisite intention to deceive, defraud the oil company and thereby gain unfair advantage. The case is that, my lord, for that I have not getting any advantage. And they have also not been falsely complicated. Kindly take note of, my lord. This is the issue settled by the division bench. In the present case, the contractor had submitted fake registration certificate. Kindly take note of. And declared month and year of manufacture of one of it is so and so transfer. It is for the oil company to establish that this fake declaration, if decided, has deceived the company and helped the contractor to gain unfair advantage. I have also not get any unfair advantage. Company has also not suffered anything. Because before date of induction, all the TTs have been released by IOCL. Then on next page, kindly take note of paragraph 23. The aforesaid factual matrix clearly shows that the incorrect declaration with regard to the TT in question was either due to reckless overzealous without any perceivable benefit. Kindly take note of. To the contractor or sharer negligence of his part. No doubt this would visit him with the penalty of blacklisting of the TT concern, but cannot translate to case of complicity which would entail cancellation of agreement as a whole and blacklisting of the entire fleet. Respondent authority failed to consider these 11 factors and mechanically cancelled the entire agreement and blacklisted the entire fleet. In the light of the aforesaid facts, we are constrained to observe, though the order of termination of the contractor and blacklisting of the entities, including the one in respect of which false declaration was made in justified, there is no justification for the imposition of the extreme penalty of cancellation of the agreement as a whole and blacklisting of the entire fleet to so and so. Accordingly, we modify the impugned order of termination and block blacklisting and direct the same shall be operated with regard to 10 TTs in question. Repetition shall be permitted to flight 4 TTs. So out of 14, false information in respect of 10. So 4 should be allowed to be continued. And the blacklisting has been cancelled also. But very recently, another matter has been moved before your lordship. And relying on this judgment, your lordship once again passed an order. And my learned friend also appeared in this matter. Well, kindly come to page 2. This is the judgment of my lord, order of 22nd April. Kindly come to page 2, second paragraph. The judgment of just I have placed before lordship that has been relied on. In this case, my lord, 9 TTs has been offered. and falsification in respect of 2 TTs. Then your lordship kindly come to page 3. The judgment of your lordship has middle portion, second paragraph. He further submits that issue involved in this petition arose before this court in so and so. This is your lordship's order. And then the division bench order has also been placed to your lordship. Then page 7, the operative portion. Page 7, second paragraph. Considering the entire circumstances, I find their substance in the prayer of the petitioner, prima facie the petitioner has placed the sufficient materials to hold that the act and action of the contempt authority in passing an impugned order, here so and so is prima facie arbitrary. Furthermore, it appears that whether the petitioner has placed the documents within 90 days so and so of the so and so, under the above observation, petitioner deserved interim order. The interim order passed by the concerned authority be hereby stayed for a period of so and so. The respondent authority shall allow the petitioner to run the 7 trucks. So far 2 is concerned. In that case, there is a false information. In my case, my lord, I have offered ballot 8. They have accepted 6. Out of that 4, I have declared that these are all free TTs. For that, either I have gained anything wrong or they have suffered anything. So my prayer is that, my lord, today so far 2 free TTs are concerned. That should be allowed to be done. And so far blacklisting and the forfeiture of security is concerned, that should be stayed like this order. The principle laid down by the division bench is that whether this is a crime and I have been benefited for disclosure of wrong information. It is the also principle how whether the oil company has been suffered anything or not. Admittedly, my lord, date of induction has not yet reached. Before that, my lord, all the 40 TTs has been released. And so far 2 TTs are concerned, that were all along free.
No, I understand your submission, but in the case there is difference. When you apply for license or come to the tender, you have disclosed that all the TTs are free.
Absolutely.
But in the other cases, there are no such false statement like that.
Registration number. So, but the first case is
No,
number.
in the first case, you have said we have 2 documents, not the tax, because new documents I have to
That
place.
case is, my lord, the registration of the order of the vehicle was false.
That means the year was
Yes, year and number
was differently noted.
Year and number on false, and the division bench held those 2 TTs should not be allowed. But for that, you cannot cancel the entire contract.
But in this case, what
I am in
prompted
a
you?
better position. What I am
Yes,
saying,
why you not said that the other 4 TTs
I have
are-
categorically stated, my lord, that on every occasion before 15 days I approach this, they all you should get it. On 10th, I have again approached. I have shown your lordship the email that on 10th when I submitted, had I submitted with saying that it is free TTs, and on 10th at any time release order is issued by the IOCL, that should have been a wrong information. Kindly take note of that. Categorically, I have stated in my petition, which prompted me. They have assured me. I wrote 2 letters prior to the submission of application. They assured me it should be given on 9th. This is my specific amendment. On 10th, I have submitted. Had I disclosed that these 4 TTs are attached with IOCL and they disclosed subsequently that your TTs have been on 10th released, that should have been a false information also. Because I am not gaining anything. No extra advantage, no extra marks. Rather, my present case is much better. One second, if you have to kindly take note of paragraph 10 of my petition. At page 8, the case I have made out. Well, prior to 10th, 2 emails I have given. On 10th, I have submitted. On 10th, again, I have, my lord, submitted an application.
But why we not inform the HPCL that those TTs are
There is no
attached to
permission,
the...
there is no scope. There is no scope. I have submitted all my documents.
Okay.
That's the only scope to fill up the document. Your petition states that since the concerned official of IOCL with no uncertain term assured your petitioner that NOC of those 4 TTs must be issued on 10th of October 2024. According to your petitioner, believing such assurance disclose all their 8 offered TTs in the bid document as free TTs. Otherwise, if petitioner disclose those 4 TTs as attached TTs or IOCL in the case of suppression of facts, your petitioner bid may be rejected. There was no malafide intention or get any additional benefit of such. Kindly take note of, my lord. Why should I do it? Paragraph, then, my lord, next paragraph. You have further states that situation beyond the control of the petitioner forced them to disclose attached TTs or free TTs with total bona fide intention, and for such bona fide suppression, petitioner did not get any extra benefit. Your petitioner states that after submission of the bid to pursuant to tender so and so, and after opening a price bid in respect of said tender, your petitioner had been selected. Then, my lord, NOC has been given. Kindly see immediately thereafter. Before the date of induction, I am holding the NOC. All vehicles have been placed. Documents have been placed. There is no illegality, nothing. Contract has been executed. 8 lakh money I have deposited. Today, what I am paying, let them file their opposition. In the meantime, 2 TTs should be allowed because there is no charge in respect of these 2 TTs. That were all along 3 TTs. And that's the observation of the division bench. The division bench hold whether I have been benefited for such false information or not, whether this is a crime or not, and whether oil company has suffered anything or not. In that case, only question of, my lord, declaration of blacklisting does arise. Blacklisting is the extreme thing. Kindly one paragraph of the division bench judgment, just one paragraph. Just one paragraph. Paragraph 19, you will kindly allow. It has been fallen from your lordship. Paragraph 19 of the division bench.
Yes.
Page 11. Aforesaid clause make it amply clear, mere submission of a forged false information with regard to one or some of the TTs would not itself have to lead to termination of the contract as a whole or blacklisting of the entire fleet. It must be borne in mind that an order of blacklisting on an industry basis would tantamount to a commercial death of the contractor. Well, I cannot use these TTs anywhere. This extreme penalty is reserved for those rigorous cases where the oil company is able to establish complicity of the contractor in the malpractice. The word complicity means active connivance or participation in wrongdoing or a crime. That is to say, fake document or false information relied upon by the contractor must be used with the requisite intention to deceive or defraud the oil company and thereby gain unfair advantage. In the present case, the contractor has submitted a fake registration certificate. Kindly take note of more criminal offense and declared month and year manufacture of one of the TTs at so and so. It is for the oil company to establish that this false declaration had deceived the company and helped the so and so. In that case, false information in regard to the registration number. So far, I am concerned whether it is attached or not. No false information in regard to number, registration. I have placed all the TTs. So far, 2 TTs are concerned, there is no charge even. All documents of the TTs have been placed as per the instruction. Security money I have deposited.
Yes.
These are my submission. I am paying for the same order as the passed by your lordship in the last matter. And my learned friend also appeared in this matter.
Yes, Mr. Chatterjee.
And so far the IOCL concerned, no SLP has been filed. May I just come back, my lord? And these 4 TTs are running, so far the division bench matter is concerned. They are accepted.
Well, this is a case with which my learned friend has approached this honorable court saying that we are at a fault, we have committed a wrong, yet to give me the exercise the equity. Is it permissible? I ask the question to myself. Or the facts, if I may portray, my lord, the petitioners participated in the tender, gave undertakings, gave declaration on oath that none of the TTs, all the TTs are free TTs. Based on that, my lord, a letter of acceptance was being issued in favor of the petitioner. Thereupon, my lord, what happens, my lord? The trucks are being sent for loading at a particular area with the particular registration numbers, and those numbers have been updated in the system. In this particular area, HPCL does not have its own facility. So it does the entire exercise through IOCL. So when all the 6 TTs were being sent for those updation of the registration numbers that they are going to be plying with HPCL, at the time of updation in the system, IOCL intimate HPCL that how can these trucks be inducted because they are already plying with us. This is where everything, the book got opened. My learned friend under the blanket was proceeding uniformly that no, there is no attachment, it's all free TTs. It only got detected by IOCL and informed HPCL that see, these are the tank trucks which are already plying with us. How come these tank trucks are being offered with the HPCL tender? That is the time when we called upon them, we show cause them, and at that juncture they come up and said, we were of apprehension that this is going to be released. And the tank trucks are till date not been released.
That has been
স্কোপ পাবি তো বলেছিস তখন কেউ ইন্টারফেয়ার করেনি নিশ্চয়ই kindly comes to the NOC. My learned friend all along has been harping on that NOC. Kindly comes to the NOC at page 407. Perhaps right facts should be demonstrated before your lordship, my lord, when they are before a constitutional court seeking an order. But I'll place the entire document. This is a letter of 27th of March 2025. This is to certify that Messrs. Azan Logistic is operating the below listed tank trucks under transportation contract number such and such, which is valid till 31/10/2025, extendable by 2 years. Kindly marks the next sentence. That IOCL has no objection on Azan Logistic to participate in other tenders. This is a no objection granted to the petitioner to participate in other tenders. Vehicles have not been released. When a no objection certificate is been issued by any oil company, there is a specific categorical assertion that the vehicles are henceforth released. They are being given NOC to participate. After participation, if they are successful in that participation, they have again to come back to IOCL and say that we have participated, we have successfully got the LOA, now you release my vehicles. Till date, the vehicles are under contract with IOCL. What my learned friend is submitting. However, suitable replacement of TTs are to be made by the transporter for release of the above TTs. But is there a document placed before your lordship today that we have substituted these 4 TTs with another 4 TTs, and this is a release order by IOCL? The answer in clear categorical word is no. My lord, for the sake of repetition, I'll again place, my lord, that IOCL has no objection on Azan Logistic to participate in other tenders through these TTs during the validity of the existing contract. However, suitable physical replacement of TTs are to be made by the transporter for release of the above TT. I ask the question to myself. If the no objection is been granted, why will IOCL again write on the second line that you offer replacement? This is purely a misinterpretation of this document and not placed on the proper mode before your lordship, my lord. Well, the first document, my lord, that I intend to place before your lordship, my lord, well, it is a case, my lord, the threshold, I would say, my lord, my learned friend has, with respect to my learned friend, he has not disclosed all documents, which perhaps ought to have been, my lord. The industrial discipline guidelines, my lord, there are declarations given by my learned friend, which purposely has not been disclosed, my lord. The agreement, my lord, which has been executed, my lord, that is also not before your lordship. Today at this time, it has to be in other way, hard on affidavits, my lord. And this is such a case where the petitioners have all along approached and participated in the tender condition with unclean hands. And it's not a case where this honorable court, my lord, which will exercise its constitutional powers to interfere in a tender. And today, I ask you, my lordship is well aware of all the judgments and the law laid down now, starting from Galaxy to NG projects, my lord. Is there arbitrariness on the part of the HPCL? I ask the question to myself. Petitioner approaches it with unclean hands, give false information. But more shocking part is, we will disclose documents. after execution of the contract, they kept on plying that vehicle with IOCL and have generated invoices and received payment. Even after execution of the contract. Now the contract was executed, my lord, on LOA was executed on 18th of December 2024. My lord, the petitioners, my lord, continued to ply their trucks with IOCL till February 2025, and I've got invoices which I'm going to disclose in my affidavits. But is it a case that my lordship will exercise its constitutional powers to give pass an order, my lord, to a litigant, my lord, who has approached, my lord, not with the proper intention? But the entire clauses of the contract will become redundant. Today, everybody will come up, give a false declaration and say, very well, I've given a false declaration, you give a relief in my favor. But what is the purpose of a contract? What is the purpose of a scope? Well, that is what has been clearly laid down by the Honorable Apex Court. Why will a constitutional court exercise its scrutiny over a tender document until and unless at the face of it shows perversity? Any document forthcoming before your lordship today in this matter, my lord, which shows that there is arbitrariness exercised on the part of the respondent corporation? But the first clause, my lord, that I wish to indicate is at page 65 of the writ petition, my lord. Clause K, the bottom of page 65.
Yes.
If any information provided in the bid is found to be false and incorrect during techno-commercial evaluation, then corresponding trucks shall be liable to be rejected. If any information is found to be false and incorrect after award of the contract, then the contract shall be liable to be cancelled and EMD security deposits will be forfeited. But what wrong the respondents have committed, if I ask the question to myself? I participate in a tender with false information. When that got detected, my lord, I approach the respondent authorities and tell that you, on a special case, grant me some relief. Statutory authorities, my lord, they are bound by the contract. Parties are bound by the contract. Nobody can travel beyond the scope of the contract. But that has been exercised. What wrong, my lord, the respondent authorities have committed? Well, the next clause, if I take your lordship, my lord, is at page 183. But this is a declaration which the tender intending bidders have to fill in and submit at the time of participation of the tender. But declaration regarding contracts with other OMCs. But what prevented them, my lord, to tell the truth? If I such and such, if your lordship comes to the next paragraph, we confirm that we measure such and such in the transport tender number such and such trucks which is currently running from the transportation contract X such and such location. If your lordship now comes to the last paragraph, I understand that I need to position the trucks within the stipulated period as per LOA. We understand that in case we are unable to position the TT's entire LOA shall be cancelled and EMD shall be forfeited. But apropos that, if your lordship now comes to page 364. But this is the attachment declaration, my lord, which my learned friend has given. Kindly see the tabular statement, my lord. Tank trucks registration number capacity. 364. Kindly see the tabular statement, my lord. Tank truck registration number not applicable. Capacity not applicable. So, my lord, at the stage of participation of the tender, my lord, these false statements have been issued. When there is a
The declaration about the contract with other OMC.
other OMC, which I just played at page 183. That was the format, and this is a field declaration. I understand that I need to position the TTs within stipulated time as per LOA. We understand in case we are unable to position the TTs, entire LOA will be considered, EMD will be forfeited.
Format.
But the next document that I take your lordship is at page 179. Well, the relevant clauses are, my lord, this is also an undertaking which have to be affirmed by them on a stamp paper with a notarized version, my lord.
Page 175.
179, my lord.
179.
But I will take your lordship. Well, this is the format, my lord. If I may place clause 4 and clause 7. In case the transporter is unable to provide NOC as above from OMC where the trucks are under the contract, LOA placed on the contractor shall be liable to be cancellation. But here, my lord, that NOC comes into foreplay. IOCL gives them a NOC that we give you liberty to participate in tenders. In the event you are successful in any of the tenders, give a replacement of those 4 treaties which are running with IOCL, and then a formal NOC will be issued. Any document before your lordship today showing that yes, we have replaced the 4 tank trucks, and so these 4 vehicles are released. Clause 7. We further confirm that the details as furnished by us have been verified and found correct. We undertake to place the tank trucks at the disposal of HPC in the case the contract is awarded in our favor. If any information, kindly sees, if any information is found to be false and incorrect during techno-commercial evaluation, then corresponding truck shall be liable to be rejected. If any information is found to be false and incorrect after award of the contract will, the contract, if awarded to us, signed contract agreement which HPCL shall be liable to be cancelled. Security deposit will be forfeited and we shall be liable to pay the oil company such damages, loss as the oil company may put due to the termination of the contract. We also undertake that should there be any action against oil company resulting in damages whatsoever nature to oil company on account of award of contract in our favor, on the basis of misrepresentation, we keep the oil company completely indemnified against all clauses, losses, litigation actions, etc. Now, if your lordship comes to page 352, my lord.
Three
352.
Yes.
My DT, this is the affirmed undertaking which I had just placed. That was the format, my lord. This is the affirmed undertaking. My lord, clause 4, identical undertaking given by them. If your lordship comes to page 354.
Yes.
That ideal. I'm not troubling your lordship by placing the entire document. But all along, a bidder, my lord, is giving falsified information, knowing fully well that he is going to suffer consequences if he's been caught. And once he's caught, now he's before the court saying that, yes, I've done a wrong. You exercise the power of equity, grant me relief. But he was always in open mind that I am with intention giving forged, falsified information. But thereafter, my lord, the LOA was being issued on 18th of December 2024.
Page
382. The LOA dated for 6 duties. 382.
Provisional letter of acceptance.
But this is issued on 18th of December 2024.
Yes.
If your lordship comes to the next page, clause 5, you are required to comply the above formalities within 15 days from of the date of this LOA and place the tank trucks for induction immediately thereafter. But if your lordship comes to the next page, now the third paragraph from the bottom, all terms and conditions agreed by you in the tender number such and such and corrigendum published thereafter will be part of this LOA and will become part of the agreement. But if I take your lordship now to the last paragraph, you will have to comply with all the formalities as specified in the LOA within the specified time and enter into the contract agreement at the respective location, failing which LOA may be cancelled and necessary action will be taken by zonal office such and such as per tender contract term conditions such and such and such. So all along, my lord, it has been indicated to the petitioner, my lord, that in the event there is any false information that we obtain that is being detected, you are going to suffer consequences. Now, if your lordship now takes up, my lord, the agreement, my lord, the agreement has not been made part of the writ petition. We do not know the reason for the same. But this agreement was executed on 11th of February 2025.
Yes.
But the relevant clause, my lord, is clause 7. My lord, this shows, my lord, all the 6 TTs which were being offered. At that juncture of the execution of the agreement, my lord, the respondent authorities was also on a bona fide belief that all the TTs are free TTs. Otherwise, this agreement also would not have been executed. But this is a clear case of misleading the corporation, and the agreement was being executed, my lord. Clause 7, my lord, shows the list of TTs, my lord. Clause 22 of this agreement if your lordship sees, my 22D.
Yes.
Well, I just place the paragraph once. Notwithstanding anything to the contrary content herein above, the company reserves the right to terminate this agreement forthwith upon or any time after happening of any of the following. Well, the other clauses are perhaps not irrelevant. If clause D, if any of the information submitted by the carrier in the tender is found to be incorrect at any time. E, breach of any of the terms of the tender or conditions of the agreement by the carrier. But so these are the 2 reasons for which, if been detected, his contract will be terminated. Now, if your lordship, my lord, comes to clause 25. In the event of the carrier's failure to fulfill the contractual terms resulting in the termination of the contract, the company reserves its right to forfeit the security deposit provided by the carrier. So these have all exercise are being done in terms of the contractual terms. Now, if your lordship now comes to one additional fact, my lord, which my learned friend has also not pointed out before your lordship, my lord. But out of the 6 TTs that were being offered, 4 were being inducted with IOC. My learned friend has contended that 2 of the treaties are free and were applying, my lord. But I have taken instruction, my lord, with regard to one of the TTs in respect of the two TTs bearing registration number 0292 is still not released by IOCL. That I will put on affidavit. So practically today, it stands that only one TT is available.
So among two TTs, one TT also attached with the
Is not released by IOCL due to payment issues. Bearing registration number 0292. And only one TT has been inducted on 15th of March. Now, if your lordship comes to the show cause notice. Well, before I take your lordship to the show cause notice, I'll take your lordship through the industry guideline. This also has not been disclosed by my learned friend. But if your lordship comes to page 4 of the internal page 4 of the guidelines, my lord, clause 2.1.2. Huh? Update. It annex but 2.1.2.
Yes.
During the contract period or extension of contract, renewal of contract, TT shall not be used for any product other than the designated petroleum products. And kindly marks the second part, will operate only for the oil company with whom the agreement has been entered into. Well, what I have indicated beforehand, my lord, even after the LOA was being issued, the 4 tank trucks were plying with IOCL. Invoices were being raised, payments were being issued. So, my lord, it's a case with my learned friend is one benefit of both ends. First, I participate in a tender giving falsified information. When it has been detected, my lord, then I continue doing it that way. And I will again come to those documents, my lord, when the letters have been issued to IOCL and what IOCL has written also to us. Those are shocking at the face of it, my lord. But the next clause, my lord, which I intend to rely on is clause 8.2.1. But this is also one of the criteria, malpractices or irregularities that may be indulged in. But this shows, what are the reasons, that this perhaps isn't much of a importance, my lord. If your lordship now comes to page 24, clause 8.2.2.14. For the second last clause.
Yes.
Unauthorized use of TT outside the contract. Well, here is a case where rightly, admittedly, the TTs have been plying, my lord, even after execution of the LOA with other oil companies and not disclosed. But what are the consequences, my lord? TTs will be blacklisted. If your lordship now comes to the next clause, 8.2.2.15, entering into contract based on forged document or false information. Entire fleet along with carrier to be blacklisted, HD to be forfeited, and transportation contract will be terminated. But I pause here and ask this question to myself. Any act or actions done by the corporation contrary to this? What has been stipulated in the tender conditions, LOA, contract, has been exercised by the respondent. But there is no illegality, no arbitrariness, and therefore constitutional court will not enter into judicial review in expressing the tender conditions. Law is very clearly laid down as your lordship is well aware of. But the next clause is also important, my lord. 8.2.16. Entering into a contract, for same TTs with other oil companies. Concerned TT shall be blacklisted. This is exactly what has been done. Now, if I take your lordship now to the show cause notice. Now, the show cause notice is at page 404. But before that, my lord, 4 documents, my lord, which I wish to hand over to your lordship, my lord. But this is a checklist of documents submitted by the bidder for induction of the TTs. But these are 4 sheets of paper in respect of 4 of the vehicles, madam.
This is the checklist.
This is a checklist. My lordship sees the first column, serial number 3.6. In contract with any other OMC, yes or no? This is a categorical remark given by them is no. So, my lord, knowingly, fully well, I keep on giving falsified information and with open eyes that if I get detected, actions will be taken against me, my lord. Yet, my lord, my learned friend is coming up and seeking order of protection from this honorable court. But all documents, and at the face of it, I am showing. This is a fit case where this honorable court will not exercise its discretion at all. But the show cause noted is at page 404.
Yes.
But page 403 is the show cause notice, my lord. But subject, show cause notice against false incorrect declaration, violation of terms and condition in tender such and such, and bulk transportation agreement dated such and such. This is in reference to the provisional letter of acceptance dated such and such issued to you against the following 6 tank trucks offered by you pursuant to the tender such and such. Consequently, a bulk petroleum product road transportation agreement was entered into by and between HPCL. After signing of the above mentioned transport agreement, via your email dated 13/3/25, you have confirmed that all the above mentioned 6 TTs offered by you are ready to take load. But now, if your lordship, apropos this, I will, for the sake of repetition, my lord, I will take your lordship once to page 406. 407, my lord. But this is a show cause notice which mentions that on 13th of March 2025, they are offered for offering of all the tank trucks, and kindly sees when the no objection certificate was issued by IOCL for participating in other tenders. That is of March 2025. Now, if your lordship comes to the next page, it is pertinent to note that you have submitted a declaration under Annexure 11 to tender such and such, wherein you have confirmed that none of the 6 TTs offered by you are running under any other transportation contract with any of the OMCs. Further, you have submitted an undertaking dated such and such, confirming that none of the offered TTs are running other contracts with any other OMCs. If the case is otherwise, you are required to submit a no objection certificate from the OMC for which your tank trucks are plying, which you have failed to do so. Further, in the list of documents to be submitted by the bidder for induction of TT submitted by you, your specific response of no indicates that the TTs are not in contract with other OMC. But these are the list which I just handed over. Hence, the corporation approached IOCL for induction of 6 TCs in the system for taking MSHG load. Subsequently, IOCL informed that the following 4 TTs are already in the valid contract of IOCL Bongaon by email dated 23. Well, these are just which I indicated at the threshold. It got detected mistakenly. Everything was going smoothly. Before IOCL, when it was sent to that IOCL premises for induction for those updation of those MHHSG load, from their system they detected and informed us that how are these TTs been inducted, my lord. It appears you have submitted false information concerning the aforesaid 4 TTs during the tender process. Therefore, you have violated the following tender clauses of tender document, transport agreement dated such and such, and transport discipline guideline dated such and such, and liable as follows. My clause 45K of the tender document, my lord, if any information is found to be false or incorrect after award of the contract, then the contract shall be liable to be cancelled and EMD will be forfeited. Well, clause 22D of the transport agreement, my lord. My DEF, which I have already just placed, my lord, I'm not repeating, my lord. Clause 2.1.2 of the transportation agreement guideline also, my lord, I have placed, my lord. Then, my lord, clause page 405, my lord. Clause 22, the middle of the page, my lord, not extending anything contrary to the anything to the contrary content above. Herein above, company reserves the right to terminate this agreement forthwith upon or any time after happening any of the events. But this also I have placed, my lord. If I take your lordship now directly to page 406. Therefore, through your act of providing false, incorrect information regarding the fact that they are not running under contract with any other OMC pertaining to 4 TTs that you have offered under the transport agreement, you have violated 45K under the head instructions to bidder under tender document, clause 22D, E and F, and clause 2.1.2 and 8.2.1 of the transport discipline guideline. Hence, we are entitled to terminate the transport agreement, forfeit your security deposit, blacklist all your 6 TTs, or take any other action as per clause 45 under the head instruction to the bidders under tender clause 25 DEF and 25 of transport agreement and clause such and such of the transport discipline agreement. But skipping the next paragraph, your lordship comes to the next one. In case no satisfactory explanation reply is received from you within 15 days from date of receipt of this notice, it shall be construed that you have no proper explanation to submit in this matter. Termination of transport agreement, forfeiture of security deposit, blacklisting your TTs. In case that appropriate action as deemed fit shall be taken as per provisions of the tender transport discipline guidelines such and such. Now, my lord, kindly sees their reply. Which starts from page 408. My lord, I need not trouble at the admission stage. We need not trouble, my lord. তুমি তো দিয়ে দিয়েছো। But if your lordship comes to page 409. The third 3 lines from the bottom of that particular paragraph. Accordingly, we filled in the tender documents. Has your lordship got it? We filled in the tender documents and declaration disclosing that none of the above of those offered 6 TTs running under any of the transportation contract with other OEMs. Well, this is a clear case of admission by them that they're knowing fully well they have submitted documents giving falsified information. If your lordship now comes to the next page, my lord. But 3 lines from the top, my lord, however.
Yes.
However, due to some pending formalities, such treaties could not be released, but we have been given firm assurance that all formalities have been completed by 9/10/2024, and without further delay, all these 4 attached treaties shall be released by the IOCL. Accordingly, as per assurance, we submitted our duly filled e-tender on 10/10/2024, and on 10/10/24, we again sent mail to IOCL for immediate release of the 4 attached treaties. Or it was with open eyes that they participated in the tender, knowing fully well that their tank trucks are plying with other oil companies under the contract manual. Now, if your lordship now comes to the last paragraph. Second last paragraph. Ultimately, on 27/3/25, NOC in respect of all the 4 TTs have been issued by IOCL, which I have just placed. It's not a formal NOC of release of the tankers, since there were repeated assurances by IOCL Guwahati that all 4 attached TTs shall be released before submission of a e-tender with the oil company. We were under the impression that if we fill the dotted column of your tender documents and declaration that our 4 those offered TTs are running other transport contract with IOCL, that shall be a false undertaking and declaration which may be debarred us to participate in the subject. So, my lord, they know there is a situation, they know the fact that if they provide false information, consequences will follow. Now, if your lordship comes to the next page. We have any malafide intention to suppress and conceal any material facts or misrepresentation, but there may be little mistake, rather misunderstanding with bona fide intention. But I ask a question to myself, the conduct of the petitioner, does it show it is a bona fide mistake? Accordingly, we do hereby request you to allow us to place all our 4 offered TTs for induction at any day by accepting the NOC dated 27/3/25 and allow us to load petroleum product and transport the same through all 6 offered TTs. But what is my learned friend offering? 4 TTs are not being released by IOCL. 5th number of TT is held up by IOCL because of payment issues. Only 1 TT. Does the contract, well, there is a specific provision of the contract which says if there's an incomplete fleet, no contract, no execution can be done. Before parting, we again request you to consider the entire episode which prompted us to declare that none of our offered TTs are running under any transportation contract with any other OMCs, and it is our expectation and trust that mistake, if any, is a bona fide one. For that, we may not be penalized, we may get an opportunity to show our performance with the esteemed company. So in clear terms, my lord, they say that we have given a forged document. My lord, after the show cause was been issued, my lord, since it is a situation which arises of termination of contract and blacklisting, my lord, we offered them a personal hearing. Kindly comes to page 413.
Yes.
This is the minutes of the personal hearing which was being conducted on 7th of March 2025. All the officers of the respondent were present and also the petitioner. Now, the first paragraph, I will only place, my lord. Transporter reiterated that they did not declare the TTs in OMC contract in tender document under the impression and verbal assurance from IOCL that they will give NOC. However, when they approached IOC from NOC after receipt of LOA, they got verbal information from IOC that all their 4 TTs are already released and LOC will. But this is neither here nor there. These are all imaginary stories that have been made, my lord, when they have been bought in the clutches, that now you are going to be hauled up for giving all falsified information. You are facing a blacklisting and termination of the contract. This is the time all these stories have been portrayed. But the most vital document which your lordship has to take into consideration is of 27th of March. The NOC letter. It's not been released at all. Well, here is a case, my lord. I can place these documents on affidavits, my lord. Or Lordship, my lord, considering all these documents, my lord, Lordship can hearing now decide the writ petition itself, my lord. Because I have the documents that I intend to rely on, my lord. I've already shown before your Lordship, my lord, that there is corresponding from point, if I take an example from point 1 to 10, all are false information. And at the end of it, in reply to Shokas, they say, yes, we have given a false information. Kindly excuse us, this is a bona fide mistake. But the entire clauses of the agreement will become redundant. But every simple contractor will come with falsified information and come up before your lordship and say, this we are doing it. Kindly exercise your equity. Will the constitutional court interfere in all these situations, my lord? And there is no arbitrariness at all. What is the arbitrariness or illegality on the part of the respondent authorities, my lord? But we, on good faith, my lord, inducted them only at a situation where they got detected and been caught by another oil company, when entire episode got surfaced in front of everyone. Well, these are my submissions.
Okay. A lot of submission has been advanced by my learned friend. So let you kindly turn to page 112 of my writ petition. I have placed this. Once again, I am placed. The clause 6 of the general terms and condition. When I have to place the NOC. Clause 6, I am reading well at page 112. For tank trucks under operation with any other oil company, an unconditional NOC is to be obtained from the concerned oil company for placing the same fully in the service of HPC against this tender NOC. NOC to be submitted at the time of induction of the tank truck.
But I pause my learned friend at this juncture, my lord. Will this clause be applicable, my lord? All along, they have made out a case that my trucks are not plying with IOCL. Now, my lord, they come.
Okay.
For this reason, my lord. No, this is all.
So, my lord, NOC to be submitted at the time of induction of the tank truck, not before agreement, not before placement of the vehicles. It is the last stage. After offer letter, deposition of money, placement of all vehicles, testing of the same, all original documents, then my lord, agreement, subsequent thereto, I shall show to your lordship from the offer letter itself. My learned friend says my vehicle was flying at the time of agreement. Is there any bar? I have to place the NOC on the date of induction of my vehicle, which is subsequent to the date of execution of the agreement. I shall show to your lordship from their documentation. Now your lordship kindly come to page 364. When the NOC is required to be placed, is their document. 364. My learned friend says I have not disclosed all the documents. My case is that yes, I have stated so. As per assurance of the IOCL, kindly see the top declaration regarding contract with OMCs. The part and parcel of my tender document. I have said not applicable. I admitted that I have said not applicable. It is a false statement. I'm not saying. But I have annexed all the documents. It is not the case that I have suppressed any material facts. Now, your lordship, kindly come to page 382. The offer letter. 18 December, I have received it on 2nd January 2025. Paragraph 13, page 10, I have stated so. Lordship, kindly come to page 383, clause number 5. You are required to complete the above formalities. What formalities? Kindly see, my lord. 1, 2, 3. Security deposit. Please bring the original documents of MSC, clause 2. Please bring the original documents of owned attached tank trucks offered by the dealer. All I have done. Next line of the clause 5. Within 15 days, 90 days, in case of transfer of the, kindly see 4. Please note that as per general terms and conditions, execution of agreement, placement of it is less than number mentioned also. Then 5. you are required to complete the above formalities 15 days or 90 days in case of so of the date of so and place the tank trucks for induction immediately thereafter. Does it suggest I have to submit my NOC prior to agreement? Does it suggest that I have to submit the NOC prior to placement of my vehicles? Whether I am running it or not, even after agreement, is there any clause that my termination would be given effect to? It says after completion of all formalities, immediately thereafter. What is the formalities? Execution of agreement up to.
Yes.
Now, Your Lordship, kindly come to page 407. Top capital, no objection certificate. From the bar, it is saying it is not a NOC. Is it the case of the oil company that my license has been terminated for non-production of NOC? It is from the bar. My learned friend says this is not at all a NOC. The caption says no objection certificate 27 March 2025. It has already been issued. Whether I am placing new vehicle or not, it is immaterial. And this is not the case of the HPCL authority. What they have rejected, why they have terminated, only on sole ground that I have given in my application that all TTs are free. Can they make out a case which is not in the impugned order from the bar? Kindly come to page 413. This is their recording, not my recording. My signature is there. Serial number 3. This is their recording. Transporter also produced NOC dated so and so issued from IOC for participating in the other names tender. Is there any whisper that this is not NOC? 4 officials and only individual me. Hearing taken place. What is the recording? NOC has been produced. Today from the bar, this is not at all NOC.
But this is not from the bar. Document will speak for itself.
Yes.
Now, Your Lordship, kindly come to order of termination at next page. Need not go through the entire. What is the clauses they have mentioned? Last part, third paragraph, page 416. Therefore, sentence, may I read my letter? Page 416. Therefore, we hereby terminate the transport agreement under clause so and so transport blacklist so and so, year so and so, on industry-wide basis under clause, kindly take note, 8.2.2.14, 8.2.2.15, and 8.2.2.16. These are the clause. Punishment has been imposed upon me. Now kindly turn to my lord, page 390. What's the clause? Before that, my lord, kindly take up my lord, the guideline. Oil industry transport discipline guideline that has been placed by my learned friend.
Yes.
Page 24. That is the consideration of the division bench. I shall show to your lordship. Page 24. Bottom portion 8.2.2.14 has been relied on by them. What it says, unauthorized use of TT outside the contract. TT conscience shall be blacklisted. Is it say all the TTs? Is it say all the TTs? 8.2.2.15 entering into contract based on forged documents, false version, enter fit along with so and so blacklisted SD so and so. The next one is very important, my lord. Kindly turn. P. Submission of forged document during contract period. Concerned TT shall be blacklisted. They have invoked, my lord, 8.2.16. What 8.2.16 says? Entering into an agreement for the same TT with other oil companies. Concerned TT shall be blacklisted. Not the all TTs. 8.2.2.16 says enter into an agreement for the same TT with other oil companies. These clause they have invoked. Order of termination. Concerned TT shall be blacklisted. For TTs, it is not their case in anywhere that another TT is also engaged IOCL and for monetary reason that has not been released. They cannot make out a case beyond their order impugned. My learned friend has submitted also to prejudice the court. I have not executed the agreement, annexed the agreement. Kindly take note of, my lord. This type of submission may not be placed before your lordship. Page 390. The procedure is that agreement shall be handed over to us. We shall endorse our signature and deposit the same to the authority concerned. And they, after their signature, that has been handed over to me. That has not yet been given. I have annexed the draft copy, page 390. There is the falsification, 390. This is the model copy, which I have signed and submitted before them. They, my learned friend cannot dispute the same. And it is still with them. They will hand over me if I win the case. Page 390 is the draft model copy. I have signed in their presence, in their office, and on 11th February 2025, that is, they have accepted. Then why should not I annex it?
Yes.
Now, your lordship, just the judgment of the division bench, one paragraph. Whatever my learned friend submission, that was the submission before the IOCL, before the division bench. Kindly turn to my lord, page 8. Previous guideline has been placed. Page 8, your lordship, kindly turn up. Whether the order of termination and blacklisting is justified. Issue. In this backdrop, we need to examine whether impugned order of termination of the entire contract and blacklisting of all 4 treaties was justified. The order of termination is based on 2 grounds. Kindly take note of. Irregular reporting of tenants areas, I was not concerned. In this case, there is no such charge. 2, use of fake documents and false declaration with regard to month and year of manufacture TT bearing so and so. What will be the consequence? Kindly come to page 11. Irregular reporting, we are not concerned. This has been dealt with in page 11. Use of forged document, false declaration in respect of 1 TT bearing registration number so and so. In our case, 4 TTs. What is the findings of the division bench? Page 11. That has been again quoted. The condition, it is in respect of my previous one. Initially, the show cause notice called upon the petitioner to submit documents to justify the declaration of month and year of the manufacture of 7 out of 14 TTs offered by them. Petitioner submitted documents and the oil company was satisfied that there was no incorrect declaration with regard to 6 TTs. However, the month and year of manufacture of 1 TT bearing number so and so was found to be incorrectly made as November so and so instead of so and so, as appearing from registration officer so and so. But kindly take note of. This has a consequence. If I place new vehicle, I shall be given priority. In this case, that false submission has been recorded. As per clause 8.1, previously this was the clauses. Now it is 8.2.16. This would justify blacklisting of TT only. However, Mr. Nag relies on a subparagraph so and so, which entirely provides in case of complicity of the contractor. Kindly take note of. It's established even in first instance of the malpractice, entire fleet shall be blacklisted. 8.2.2.16 says only concerned TT. Not all TTs. If there is any complicity in that case, then next, my lord, under condition which they entail so and so. Aforesaid clauses make it amply clear mere submission of a forged false information with regard to 1 or some of the TTs. In my case, 4 TTs. TTs would not ipso facto lead to termination of the contract as a whole or blacklisting of the entire fleet. It must be borne in mind that an order of blacklisting on an industry basis would tantamount to a commercial death of the contractor. This extreme penalty is reserved for those rigorous cases where the oil company is able to establish complicity of the contractor in the malpractice. The word complicity, that has never been mentioned in our impugned order. Complicity is not there. This is a separate clause. The word complicity means active connivance or participation in wrongdoing or crime. That is to say, fake document or false information relied upon by the contractor must be used with the requisite intention to deceive the default, the oil company, and thereby gain unfair advantage. A single word has not been submitted by my learned friend before your lordship that I have taken any undue advantage. No priority. No extra marks. The division bench says only in case of taking undue advantage by falsification. there should be an industry basis blacklisting.
Okay, Mr. Sahara.
My lord, my lord.
Continue.
My lord,
This matter
yes.
continue.
Five
PM, my lord, I
five-
have some other fixed matter, my lord.
Only reply, therefore pass the order.
Proceeding, just proceeding.
Only reply and pass the order.
On legs actually, my lord.
Judgment time is taken short.
My lord, two points, my lord, if I may indicate, my lord. This is a point of law, my lord. I'm entitled to. My lord, paragraph 22 and 23. My lord, I'm extremely sorry, I'm holding up my lordship, my lord. In this backdrop, my lord, this is a division bench judgment. Paragraph 20. In this backdrop, incorrect declaration with regard to month and year of one of the TTs by the writ petitioner did not give an unfair advantage to secure the contract. On the contrary, if such declaration, if detected, would visit him with undesirable consequences. But the next paragraph, the aforesaid factual matrix clearly shows that the incorrect declaration with regard to TT in question was either due to recklessness, overzealousness, and without possible benefit to the contractor, or sheer negligence on his part. But this is not a question of sheer negligence. But paragraph page 13 of the division bench judgment.
Yes.
But this is not a case of sheer negligence. But the judgment is clearly distinguishable, my lord, on facts. But my learned friend has also made a point that neither of the parties have not been affected, my lord. My lord, they have continued to ply the tank trucks beyond the execution of the LOA till February, and in raised invoice, received payments. Well, this I have already indicated, man.
Very
I'm coming back.
2K.
Two, that's-
आगे 2 PM
Your Lordship, may I permit to mention item number 13, Your Lordship. It was fixed at 2 p.m. today's list.
Is it, there is a not today? So what can be done? This order has been passed here.
Tomorrow 10:30, I shall take only 5 to 6 minutes. Then your lordship may pass the order. Today it will not be proper to make any further supply.
Very well. In this situation, we cannot proceed further.
For the matter which are raised at 2 p.m. I think that would be tomorrow.
All would be there like that. All will be remain in the position. Okay. Let's see tomorrow or day after tomorrow like that. Very well. Thank you.
Tomorrow 2 p.m. Tomorrow 10:30.
I must say that tomorrow and in this week I am in under disposition.
No, your lordship may. Resolution is that in absence of any parties, my learned friend's presence.
Not to participate is there. In this week I am in disposition. Only this day. The rest of the day I will not available in this week. It would appear on Monday again.
Monday.
Monday again. Monday it a first as well. Monday it a first as well. Okay. All will appear on Monday.
কাল থেকে থাকবে না?